Justice Alito?
Suppose that a jurisdiction enacted a concealed carry permitting regulation that is almost identical to the one we invalidated in Bruin, except that it requires an applicant to show that he or she is sufficiently responsible. Would that be constitutional?
So if that were implemented through a system of executive discretion, just as I was discussing with Justice Thomas, I think that there could be additional principles that come into play that would guard against that kind of licensing regime. Now, to the extent that that kind of background system was intended just to implement the bases for disarmament that reflect legislative judgments, and in other words, to check for whether you have a history of commitment to a mental institution or a criminal record or so forth, then I think those objective standards could be deployed as part of a background check system, and Bruin specifically suggested as much.
One more question. In response to my question about the provision that prohibits the possession of a firearm by someone against whom an order prohibiting violence has been entered, and the provision doesn't on its face require a finding of dangerousness. As I recall, your answer was that state laws generally do require that, and anyway, equitable principles require that. Now, suppose someone is later prosecuted for violating that provision. Would it be a defense for that person to say that the state law in question did not require such a finding, and in fact, there was no such finding in my case?
I don't think that that would provide a basis to collaterally challenge the entry of the protective order in the federal prosecution, and we don't think that there should be a system of as-applied challenges in this context, because I think that what we know is that Congress is entitled to make categorical judgments, predictive judgments of dangerousness based on history and tradition, even if there are really edge cases where that predictive judgment wasn't actually necessary to guard against a danger there. But if what you're suggesting is that there might be a state out there that is ordering judges to enter the subparagraph C2 prohibition without any basis to think that physical force is likely, I think a person would have a very strong due process challenge to that kind of law, and that law would likely be invalidated on the separate basis that it doesn't provide due process if it's requiring courts to enter relief that the facts in the law don't support.